Good morning, members. We have a quorum. Let's call to order the meeting of the Bills Committee on Contracts, Rights of Third Parties Bill. This is our second meeting. The first item in today's meeting is to meet with deputations. Today, coming to this Bills Committee this morning, there are 7 deputations. Let us invite them to come in first. Thank you. We can also invite the administration to come in, please. Good morning.
written submission.
Deputations, please be seated to my left.
Good morning.
We need to wait a little because the meeting in room 1, which is the Public Works Subcommittee, is broadcasting into this room, and we need to allow them time to switch off the broadcast system first. Please hold for 1 or 2 minutes. Thank you. Today, 7 deputations or individuals have come here to express your views. Let me remind you that when you use the earpiece, channel 0 is the floor. And if you like to tune into the floor, that is 0. And channel 1 is Chinese, channel 2 is English. When you speak, please speak into the microphone so as to facilitate interpretation. When you speak, please use either Chinese or English. Avoid using a mixed code. Each deputation or individual will have 5 minutes to speak. I'd like to remind you also that when you address this panel, your remarks will not be covered and protected by the Legislative Council Powers and Privileges Ordinance. And if you have submitted any written representation, those, again, will not be covered or exempted by the Legislative Council Powers and Privileges Ordinance either. Now I'd like to invite deputations to speak now. First, from the Construction Industry Council, Ms. Miranda Yap. Ms. Yap, please.
The Construction Industry Council has reviewed the bill, and we, in principle, support the implementation of the bill to grant a non-party to a contract the right to enforce terms under the contract intended for its benefit. We consider that the construction industry will benefit from the rights conferred on third parties by the bill, which, if properly applied, will do the following. A, provide a more straightforward route to allow interested third parties to enforce their rights. B, ensure that classes of third parties are protected even if the particular users or beneficiaries of construction works cannot be identified. C, avoid the formalities of execution of warranties and assignments involving multiple parties. Chairman and members, we understand that there are concerns raised by some construction industry stakeholders that the bill may create additional potential liabilities on contracting parties. As we see it, however, as currently drafted, the applicability of the bill is very much subject to express provisions in the contract. It does not in itself increase liability as such, but if the need arises, should provide an efficient means to address third-party rights for the construction industry. Chairman, that's all I wanted to say for this.
Thank you, Ms. Yip. Thank you. Mr. Lee Mason, Assistant Professor of Faculty of Law from the University of Hong Kong. Mr. Mason, please.
Thank you. The first comment I'd like to make is that there's no provision ousting the applicability of Section 7.2 of the Control of Exemption Clauses Ordinance. This is the one that concerns exemptions from liability for loss or damage caused by negligence. Now, as such, the absence of this provision, of such a provision, means that where there's an exemption clause in the main contract which excludes or limits the promisor's liability to the third party for breach of a contractual duty of care, this clause will be subject to the reasonableness test in Section 3 of the Control of Exemption Clauses Ordinance. In other words, Section 7.2 of the Control of Exemption Clause Ordinance is wide enough to possibly prevent the promisor from excluding or limiting his liability to the third party if the relevant exemption clause fails to satisfy the reasonableness test. Whereas in the UK Act, there is a provision specifically disapplying the UK's equivalent of Section 7.2 of CISO, which thereby prevents the third party from having the promisor's exemption clause avoided for being unreasonable. Now, although the Hong Kong bill here may appear more third-party friendly, it creates uncertainty for the contracting parties, most particularly the promisor, whose liability to the third party may ultimately not be exempted, despite himself and the promisee having freely agreed that it should. Clearly, this flies in the face of the main driving force of the reform, which is to give effect to the intentions of the contracting parties. And it's something I think is worthy of attention, given that the UK Act expressly deals with the issue. So essentially, if Section 7.2 of CISO is not disapplied, then the promisor is actually open to more potential liability than he contractually bargained for with the promisee. The second point I'd like to make is with regard to Section 11 of the bill. This is regarding protection of the promisor from double liability. Now, under Section 11.4, you can see that the court or arbitral tribunal must reduce any award made to the third party to the extent to which it thinks appropriate to take account of the sum. The first point here is just a drafting point, actually. Perhaps the words recovered by the promisee would be better at the end of that provision, just to make it clear to which sum the court or arbitral tribunal is to take account of. Secondly, to the extent that Section 11 is designed to protect the promissor from double liability, it does so only insofar as preventing double recovery for the same loss. There may, however, be circumstances, very occasionally, where the promisee suffers personal loss as a result of the promissor's breach. And this loss is separate to the third party's loss. This seems to have been overlooked by the Law Reform Commission, and at paragraph 4.146 in their report, they essentially, they're agreeing with the English Law Commission that a promisee would be left with no corresponding outstanding loss once the third party had recovered damages. This is not quite right. If the third party claims and recovers damages before the promisee, on which the bill is actually silent, then the promisee should still be able to recover for any personal loss of his own, which is over and above any damages previously recovered by the third party. Furthermore, the provision should make clear that even if the promisee claims damages for his personal loss first, then any subsequent award to the third party should not take into account the sum representing that loss. This seems easily achieved by including in Section 11.4 a reference to the sums recovered of the type listed in Section 11.3b. And finally, on this particular point, although Section 11.4 intends to prescribe that any third party's damages should be offset against any previous recovery for the same loss by the promisee, there is no express provision dealing with the promisee's duty to account to the third party for those damages recovered in relation to the third party's loss. Although this could reasonably be left to the common law as part of a restitutionary claim, an express provision that the promisee will account to the third party for such damages would make the position clearer and arguably reduce the likelihood of litigation. I'm wary of time. I have a couple of other points, but I can leave it there if you...
Okay, if you got other... Do you have any written...
你有冇其他嘅即係書面嘅意見書咧？如果係嘅，可以交俾我哋嘅。The next one is Mr. Patrick Chen from the Hong Kong Confederation of Insurance Brokers. Good morning. Our confederation doesn't have a written submission, and because the schedule is rather tight, it's just several days ago that we received the notice of this public hearing. But then insurance brokers, in some cases, will participate in drafting the insurance policies, especially for major commercial insurance contracts. But in most of the cases, the insurance contracts are drafted by the insurance companies. So the brokers play a subsidiary role in a sense. And we have a close dialogue with the Hong Kong Federation of Insurers as well. And I noticed that they have submitted a submission dated 7th of May, which is tabled before us. And it also attaches a letter dated January 2013, seeking for clarifications of certain issues. We have communicated with them. And for certain issues, a clarification needs to be made. The Hong Kong Federation of Insurers has also sent in submissions relating to the implementation of the UK Act, and we agree with their views. The insurance companies can include certain provisions in the insurance contracts on the applicability of the bill, then that would make things clearer for everyone. So that's what I wanted to say. Thank you, Mr. Chen. The next one is from the Chartered Institute of Arbitrators, East Asia Branch, Dr. Yang Fan.
The Chartered Institute of Arbitrators East Asia Branch supports the bill, and we welcome, in particular, Section 12 of the bill, which clarifies the third-party rights in arbitration agreements. And that's all. Thank you.
That's very quick. Thank you very much.
Next one is the Life Underwriters Association of Hong Kong Limited, Mr. Lewis Chair. Good morning. In 2012, we made a submission on the bill. We are the frontline workers. The Hong Kong FI has sent in a submission, and then the insurance contracts are really drafted by the insurance companies. And we have closely communicated with the Hong Kong FI on the matter. On one of the clauses, Clause 6, we have a great concern. This clause protects third parties, and it restricts the contractual parties in rescission and variation of contracts. If in the rescission and variation, the third party's interests are going to be affected, a notification has to be made to the third party. Now, 6.3 says that the contractual parties can make an express term to vary the contract without the third party's consent. But then in 6.4, it says that the two contractual parties have to take measures to make the third party aware of the term. Now, in our contact with the clients, it's the insurance companies and the frontline workers who are doing that. Well, there is a practical difficulty in doing that. Now, say if a client takes out an insurance policy, and after some time, the client may make a claim, and the insured amount may be reduced. Now, if we are to invoke that clause, then we will have to notify the beneficiary, and that poses a practical difficulty. Now, a second question is about how to get in touch with the beneficiary. That may not be possible sometimes. Now, the insurance agent sometimes may not want the agent to get in touch with the beneficiary at all. Now, if the beneficiary is a child, well, some parents do name their children as beneficiaries, and in those cases, who can represent the children to give the consent in the variation of the contract? So for our frontline workers, we need more guidelines on that. So if the bill is going to be enacted, please give us more guidelines on how to deal with that particular clause. Next one is the Chartered Institute of Building, Hong Kong, Mr. Lam Wai Choi. Chairman, good morning. For the construction industry, we usually have a main contract. The main contract usually covers issues relating to third parties. Usually, in the main contract, we will look at the requirements of the government departments, the property developers, and the contractors. Then the main contractor will buy our insurance based on the main contract. The main contractor or the frontline workers will be bound by the main contract. Now, CIC just said that protection should be afforded to the construction industry. But for the construction industry, we're more than willing to cooperate with the government on that. Now, Mr. Chair mentions rightly that clear clauses or terms should be provided in the contract. I think that's very important. we may take our insurance policy with an insurance company, and we may not be very clear on how the insurance policy can protect third parties. And we might take out an insurance policy which protects third parties, but then the third parties may not understand what is going on, and they're not afforded the relevant protection. So I think it's important that clear terms be written into the insurance policy so that the third parties are made aware of their rights. And also the contractors should know about the rights of these third parties. Thank you.
We'll be with is Mr. Peter Clayton of the law firm Pinsent Masons. Mr. Clayton, please.
Good morning, Chairman. I'm here on behalf of the Hong Kong Construction Association, and the submissions from the Hong Kong Construction Association are that the introduction of this legislation is not considered right or necessary for the construction industry, or indeed for the end users of the buildings and projects which the industry delivers, and therefore an exclusion is sought from the legislation. The reasoning for that, and the very strong and cogent reasons for that, are that one of the distinguishing features of the construction industry is its reliance on very large, complex contractual chains. This has already been talked about by the previous speaker, where typically starting with a developer or a government department or end procurer, you will then have a series of contracts through main contractors, subcontractors, suppliers. There will be usually agreements with designers and other consultants involved in the design, construction and supervision of the construction works. And of course, in a sense, all the participants in the contractual chain are working to benefit the end users and the various stakeholders and so on who will use the completed projects. So there is potentially many questions of what work and what provisions in contracts are going to benefit third parties. And the industry already has a tried and tested method for ensuring that third parties have relevant rights where the parties intend that to happen through the use of collateral warranties and transferable guarantees and so on. And what that requires is for parties to set up specific contractual structures, but ones which use fairly standardised and, as I say, tried and tested methods of providing collateral warranties. The drafting and execution of those documents is not a particular burden for the industry, and in effect what this legislation is proposing is that parties can still do that by identifying in their contracts the third parties that are to benefit and the nature of the rights that they are to enjoy and so on and so forth. That all requires scheduling out and detailing carefully in contracts, and one effect of this legislation will be to require the industry to go through its various contracts and consider its position on each project and consider what rights need to be addressed in their contracts and so on and so forth. So in a sense it's the same exercise that is done already in relation to collateral warranties, except that there is going to be a lot more work for the legal industry. Frankly, it's not something that's necessarily going to benefit the construction industry or the customers and end users of the construction industry's product. And of course, what will undoubtedly happen is that the larger and more sophisticated parties in the field of construction and development and so on will stick with the current approach they have with collateral warranties. That's essentially what's happened in the United Kingdom, for example, and they have the option in any event to exclude the effect of this legislation by express words. So if the legislation is implemented as covering construction, I suggest that many parties will carry on as before, using the collateral warranties and excluding the effect of the Act. And where the Act is really going to have an effect will be on the smaller, less sophisticated parties involved in construction. But then, is that going to provide any particular advantage to purchasers, tenants and so on? not really. Where they are going to have to go if they're to seek to rely on the Act in cases where parties haven't expressly dealt with who's to benefit is to sections 4.1b and 2, which is going to mean that they've got to look at contracts to see which contracts purport to confer a benefit on them, and to try and establish that they're identified as a member of a class or answering a particular description. So that is potentially a rather legally uncertain situation, and the effects of that, well, as I say, uncertainty. Also, parties are going to be looking around trying to understand who has been active in the contractual chain, who might they have a claim against. They're going to have to try and find out what their contract terms are, whether those terms express benefits and so on. And what that could lead to is multiple proceedings instead against various parties in the contractual chain, rather than the current position where a single claim would be brought against the procurer or the developer, and the developer in turn would seek recourse to other parties in the contractual chain. So again, we don't see that particularly benefits, if you like, the consumer and the end users. It's going to generate uncertainty, it's going to generate additional cost, and frankly more work for lawyers, which is, I suggest, not the objective of this legislation. And I think it's far better, if there are concerns about delivery of the industry, and the Hong Kong construction industry fully accepts that contractors should deliver to contractual standards and be responsible for work that they are responsible for, and for correcting defects and so on. But far better to focus on increasing the rights of consumers and end users in terms of their rights against developers and procurers, and limiting their ability to exclude liability and avoid responsibility for delivering developments or units to required standards. So in summary, the principle of the legislation, there's no comment on that, but it's suggested that there should be an exclusion for the construction industry.
Okay. 好啦，咁就聽完7位團體或者個人嘅意見，其實有好多唔同嘅意見，包括有啲 drafting point、啲 construction industry 嘅 exemption， 或者甚至係其他嘅我哋現有嘅ordinance， 譬如 control exemption clause ordinance 等等唔同嘅意見。咁我哋而家以下俾翻時間政府回應先，跟住呢，我哋嘅委員當然會對頭先各位團體發表嘅意見，亦都有意見或者都有問題想問佢哋嘅。咁我哋一間先做呢個部分。而家我哋請政府作一個整體嘅回應先。唔該，黃生，唔該你。
多謝主席。關於剛才幾位代表就今次個條例草案嘅。
Well, earlier on, we have heard views from deputations. We want to do a good piece of legislation so that there is a good framework to protect third parties' rights. We particularly welcome the Construction Industry Council's views, and also Dr. Young's views that they support the bill. And CIC said that the bill can help protect third parties' rights, especially in the construction industry. And also Dr. Young talks about the arbitration clauses, and we hope that that can help deal with third parties' rights. As for views expressed by individual deputations, I can give an initial response. Perhaps I will respond later on in detail in writing. We have heard many views. Professor Mr. Lee Mason, in the UK Act, Clause 7.2, it deals with third parties' rights. We didn't adopt the UK Act's clause, and that is because we want to implement the recommendation of the Law Reform Commission's report, paragraph 4.127, and they have asked whether we should allow third parties to rely on exemption clauses. The UK Act didn't use the control of exemption clauses ordinance. Well, the name is different, of course. In the UK, it's Cap 71. Initially, we thought that an exemption or an exclusion should be made.
即係話容許第三者第三方仍然可以依賴呢個條文去保障翻第三方喺處理關於即係呢個豁免條款上高嘅情況。咁呢點我哋係表達認同，所以根據成個即係建議即係法律。
We, after listening to third parties, we think that we should still allow third parties to be able to make use of the exemption clauses, and we believe we should still depart from the UK approach and adopt the Law Reform Commission's view. And there was mention on double liabilities. We are aware that to a large extent, the LRC has already addressed these issues. For example, whether or not we should give particular attention to this, and that is when third parties want to claim the promisor directly, and if this happens before the promisee does so, should there be a particular clause for it? According to 4.146, after considering the UK Commission's view, we believe that we should not have to provide express provision for this, and we believe para 4.146 of the report has already dealt with this. And it was also mentioned whether there should be an express provision for dealing with this, and that is when the promisee has already got the compensation. Should there be an express provision in the law to say that such should be transferred or mentioned to the third party? Actually, in para 4.143 of the report, this has been discussed as well. The proposal is that there needs not be an express provision. This is again with reference to the UK approach, so that the court will be able to help develop the law in this respect, so we do not need an express provision for this. We have taken on board the view of the LRC, and that is why the arrangement is absent from the bill. In fact, this is aligned with the UK approach. And as for the other deputations, I can see views expressed on the insurance industry and the construction industry. With regard to the insurance industry, in 2012, in the fourth quarter, we conducted consultation with them, and we got very valuable views from them, including that from the Life Underwriters Association of Hong Kong Limited and also the Hong Kong Confederation of Insurance Brokers. They have submitted views to us, and we have considered the views in detail. And that is why the legal proposals now have been drafted after considering their views. But then we are aware of one particular concern, which is quite major, and that is whether the entire third-party rights should be excluded from insurance policies. This is actually a core issue, and in the LRC report, there actually was quite some lengthy discussion from 4.183 to 4.184. There is a summary of the discussion. In a nutshell, the LLC has balanced different considerations, and in these two paragraphs, the LLC states that they do not see sufficient reason to exclude insurance policies from the bill. Actually, the bill allows parties to the contract to contract out. In other words, that they can state in the contract that the particular contract does not apply to the third-party rights. So there is this mechanism. There was a technical point mentioned, though. In certain circumstances, according to the relevant content of an insurance policy, perhaps the insured may borrow money according to the contract. Now, would that be told to the beneficiary? We think that if he is just implementing the contract, we think that would be difficult, because the framework here is that if, according to Clause 6 of the bill. If you rescind or vary the contract, then you can follow that mechanism. And if you follow the contractual clauses, we do not need anything extra. I believe the characteristic of Clause 6 is such that notice should be given only when there is rescission or variation of contract. When we go to clause-by-clause examination of the bill, you will see that there are mechanisms under Clause 6, and that is under contract clauses. The parties can actually deal with these circumstances. We can explain that later. And also for the construction industry, we understand that it was mentioned whether the construction contracts should not become something under the bill. Actually, in 4.179 to 4.182 of the RRC report, again, there has been discussion of this point. And also in the subcommittee, they have also met with the Hong Kong Construction Association. We are aware that the LLC has given detailed consideration to all relevant factors and points and has taken reference from overseas practice. And it is of the view that construction contracts should not be excluded from the bill. The bottom line is that both parties can reflect their views, and a certain construction contract can expressly state that this particular bill does not apply to that contract. When CIC spoke, it also said that, in fact, this would afford convenience, and in fact, there are benefits. As I said at the last Bills Committee meeting, Chairman, I expressed that the entire framework is to give play to the intention of both parties and to facilitate both parties so that it is easier for them to deal with unreasonable or unfair situations. All in all, later on, we will give a more detailed response in writing, but the major directions, including as to whether we should exclude certain contracts, we can see that the LRC has stated in the negative, and we also identify with the LRC's views. I can supplement if you need me to say more. Mr. Wong, you promised us that there would be a written response in detail to the deputation's views. Thank you to you first. Now the floor is open to members to ask questions or to make comments in response to the deputation's views. I have Dennis Kwok and Chen Kin Paul. Who else would like to speak? Well, I think there is time, so Dennis, you can have a go first. Thank you, Chairman. I'd like to respond to the Consumer Council's written submission. This is in paper CB 4629-01. Mr. Dennis Kwok, what you are going to say, is that going to be related to the views of the deputations? Well, yes. What I'm going to say has been mentioned by the deputations as well, but I'd like the administration to give a specific response to the Consumer Council's views. Para 8. It says that we need to protect consumers' rights, and the bill should have express provisions to state that consumers' interests are protected. This is my first question. Secondly, I'm aware that Professor Mason said that he did not have time to express all his views, so I'd like now to give him time to finish his submission before we ask more questions. Mr. Mason?
Possible to finish whatever you haven't done so, please.
Well,
Mr.
thank
Mason.
you. I'll just be very, very brief then. My points were really related to I had initial reservations with regards to Section 12, the arbitration agreement, but my initial reservations have somewhat subsided over the last year or so, particularly in the light of a recent Court of Appeal decision in the UK, Fortress Value and Blue Sky. But just in relation to that slightly, there's no provision, I note, dealing with mediation agreements. So we have one with arbitration agreements, but there's no provision dealing with a third-party right which is enforceable only by recourse to mediation before maybe going to arbitration. That seems to be missing. And one very final point is in relation to Section 13, that's the exclusive jurisdiction clause. Do exclusive jurisdiction clauses confer a burden on third parties? committee is well aware that no other common law jurisdiction has a legislative provision expressly dealing with exclusive jurisdiction clauses. The main problem, or at least uncertainty, it seems to be in the context of exclusion clauses, where the promisor brings an action in tort against the third party. If the third party wants to rely on an exclusion clause, which was conferred on him for his benefit, does it mean that a third party is subject to the burden of being forced to defend himself in the jurisdiction agreed in the main contract? Now, there are various ways of arguing yes or no for that, but the actual position is unclear because Section 13 is more or less floating in uncharted waters. Those are just a few of my thoughts, and I can provide a bit more detail in the written submissions.
Okay. Thank you. Wang Jun.
Mr. Wang, would you like to respond now? Yes, I can give some initial response. Mr. Kwok mentioned the Consumer Council's submission asking that the entire scope of protection can be wider. We understand that in the LLC report, some discussion again has taken place. Actually, after 4.40, it has stated its considerations. The LLC is aware of the concern of the Consumer Council. And the Consumer Council is saying that even if the parties are not willing, the third party should be able to enforce rights. As the LLC report states, they have considered this point. If this is going to be allowed, then it is actually going against the entire reform direction. The reform aims to allow the parties to the contract to give better play of the intentions of the contract. If this is going to be changed, and also if the two parties wouldn't like the third party to be able to enforce its rights through the court, then we believe this should not be included in the bill. Of course, the CC is looking at consumer protection, but the core of the bill is actually to better realize the wishes of the contracting parties. And we agree with the LLC that we should not exceed that principle. Just now, Professor Mason mentioned two aspects. Number one, arbitration. I knew that he agrees with this after looking at a case law in the UK. And recently, we have beefed up that clause. Secondly, on mediation, and also with regard to Clause 13 of the Bill, exclusive jurisdiction clause. First of all, on mediation. We do not have an independent clause to address mediation. That is the case. In the LLC report, there is not such a specific proposal. But actually, apart from arbitration, the LLC has included the exclusive jurisdiction clause. That is why we have not included mediation. We have given some consideration to that ourselves. And we then looked at Clause 4.4 of the bill, and that is the main principle. And that is the enforcement of the term by a third party under this subject. Section is subject to any other term of the contract relevant to the term. So if that's the case, if the contract states that if the rights have to be enforced and if mediation should take place first, then according to 4.4, you still have to act accordingly. So we'll rely on 4.4.
So, in the construction industry in particular, there may be express terms in the contract dealing with third parties' rights, which may be appropriate. Now, as for the Clause 13, exclusive jurisdiction clause, we note that this is specifically raised by the LRC. We believe that 4.4 lays out the main principle, and we believe that the principle is that the burden will not be just on the third party. We must rely on 4.4, that there may be certain rights conferred on a third party, but that may come with certain conditions. And the rights may be realized only under certain conditions. Say, for example, that should be realized in connection with exclusive jurisdiction clause. So this clause 13 is in line with the spirit of clause 4.4. I would like to follow up further, Chairman.
I understand that you've done quite a bit of research into the areas of consumer protection. It's part of your discipline. And I just want to know whether you think the present bill has sufficient or whether it could do better in terms of consumer protection.
Mr. Mason, yeah.
Thank you. Consumer protection is an issue all by itself, and it's greatly lacking here in Hong Kong, sadly. I did have a quick look over the Consumer Council's submission here. But the problem is that what they're recommending in their submission is that, I think it's already been alluded to before, this would not be respecting the intentions of the contracting parties by widening the enforceability of such a right. It would be too wide in scope, and it could arguably include an indeterminate number of potential third-party plaintiffs if we followed what the Consumer Council recommended. Promisors would just start contracting out and making that quite standard boilerplate. So rather than considering whether to contract out, it would just become like a boilerplate clause contracting out of the legislation. But as I said, consumer protection law is lacking here, but this is a matter for a separate bill. It's not something, I don't think, that should affect this third-party rights bill in front of us today. Thank you.
OK，下一位係陳健波議員，陳健波。
Next, Mr. Chen Kim-po. I'm not a member of this committee, but thank you for giving me the opportunity to speak. The DOJ already said that the Hong Kong Federation of Insurers submitted in writing and their opinions on in January 2013, and it seems that you have dealt with the issues raised. And then the Federation of Insurers has sent in a written submission, and it wanted to clarify the fact that the government has already dealt with the issues raised. If you can confirm that that is the case, then we can rest assured. But then we hope that you can give a written response to the Hong Kong Federation of Insurers. Can you verbally tell me or confirm that all the issues raised by the Federation have been duly dealt with by the administration? So we're talking about paper CB 4644/1314/01, and that is a letter dated the 7th of May from the Hong Kong Federation of Insurers addressed to myself. Mr. Wong, can you verbally confirm that the issues they raised have been dealt with? Mr. Chen, this letter is dated the 7th of May, and it raises specifically whether the insurance contracts would be excluded from the bill. Well, I said I already made a reply just now. We've fully considered the views of the insurance sector, and we've also taken into account the LRC's recommendations. We have considered each point in detail, and we may not be acceding to the each and every request of the Federation. Our overall principle is to protect the overall rights of the third parties. Now, if you can exclude altogether the insurance contracts, then that will be good. But you said that that's not possible. But then in the conclusion, it seems to be suggesting that there appears to be enough scope within the proposed bill to allow insurers to exclude the operation of the bill altogether. That's our main focus. Yes, I can confirm that. Because according to 41B and 43 of the bill, then it can achieve that effect. I.e., that is to say, if the contract, you state clearly that the contract is to be excluded from the bill altogether, then that can be done. But we have to look at individual cases. We can't exclude, adopt a sweeping or across-the-board approach in excluding insurance policies from the bill. Then that's not a good approach. Well, please respond in writing on what you said. And that is to say that in the contract signed between the insurers and the clients, that can be resolved, right? And 2 deputations from the insurance sectors are here today. Please deal with their concerns duly. And we can rest assured that this is going to be an acceptable bill. Can I supplement a bit? Now, if in the bill that an express term can be allowed to exclude the bill altogether from the contracts, then this may not be a good thing to the insurance companies. If there is a standard plate clause, then that will affect your marketability of your insurance policies. Because, say, if a client knows that the bill or the ordinance will be excluded from your insurance policy, then the clients may be worried. So if you are excluding the bill from the insurance policies, that may not be a good thing for your sector because it will affect your marketability. I think it's up to the insurers to make the decisions for themselves. Sorry, I have to attend another meeting of the Public Works Subcommittee. I look forward to your written reply. Mr. Chen Kim-po, when the bill is enacted, I hope that your insurance agents can explain to the policy holders the spirit of the bill. Next, Ms. Starry Lee. Thank you, Chairman, and welcome deputations for coming here to give your views. Mr. Wong said that the construction industry was worried at some time, but then it seems that you have dealt with the issues of concern in the industry. So I would like Ms. Yap to confirm whether your worry or concern has been dealt with. Second, now, if the bill is enacted, will it have any impact on the contracts templates of the government departments? Now, for government departments, will the ordinance being excluded in the government contract template? What's your initial thinking? Third, from the consumer's point of view, or the small-sized buyers, when we sign a contract, we have little bargaining power, and consumers are not well versed in, say, how to vary the contracts presented by the sellers. So what kind of work will the government do to raise the awareness among consumers that they can sort of change the contracts so that the third parties' rights can be well protected? As what the chairman said, the insured should theoretically be able to tell the difference with or without the ordinance. Ms. Yap first. Thank you, Chairman. As I just said, the CIC welcomes this bill, but we understand that within the industry, some stakeholders may have reservations. Well, the way the bill is drafted indicates that the detailed or specific provisions in the contract have to be considered too. As one member said, when the contractual parties believe that they don't want to invoke the ordinance, and they can exclude that, stating specifically so in their contract. So I don't think that we should exclude the construction industry altogether from the coverage of this bill. Mr. Wong, please respond to the two other questions. Ms. Lee mentioned that about a government contract template. At this stage, I can't speak on behalf of the relevant government departments. But in the LRC report, paragraph 4.45, there's been discussion on this aspect. And the spirit behind is that it is the intention of the two contractual parties to give the rights to the third parties so that the third parties can, through the court, enforce a right. And it also says that the government departments have an important role to play in government contracts. So through this bill, it can better realize the contractual parties' intention to confer rights on third parties. Third question, you have not responded. Ms. Lee, has he responded to the third question? Well, that's about consumers. On publicity work, we agree that it should be stepped up. Now, before the enactment of the bill, we believe that there should be preparation work. And we have said before that we should at least allow 6 months for the sectors to prepare. And we would also be working together, say, with the Law Society and the Consumer Council on how to promote the bill or the ordinance to be enacted, to raise awareness of the public or the small buyers so that they know about their rights under the ordinance. Follow-up. I know that you are from the DOJ. For government contracts, you don't have a notion, but then would it be good that if you try to ascertain what's happening? Now, well, will it be possible that the government department will provide in the contracts that the ordinance will be excluded because they want to avoid claims as much as possible? Well, sometimes we have received complaints from the public. There may be a contract between the FEHD and the tenants of the stores, and we say if a member of the public falls down because of slippery floor, will this member of the public have the right to enforce his right under the contract between the FEHD and the store operators? Yes, we can certainly relay your views to the relevant government departments, but at this stage, I really can't speak on their behalf. The overriding principle is to take care of the intentions of the contractual parties in their intentions to confer the rights on third parties. It may not be good to take an across-the-board approach. In the future, different government departments may take different approaches or attitudes towards this bill. Is that right? Yes, well, it all depends on the individual circumstances of the contracts to be entered into. Any follow-up from you, Ms. Starry-Lee? Any questions or comments from members and deputations? Mr. Alan Long. My understanding is this.
Actually, in many contracts, the contracting parties will create rights for third parties. Without this bill, those third parties cannot force the contracting parties to discharge clauses that create third parties' rights. So my understanding of this bill is really just to tackle this point. That is why Mr. Peter Wong said time and again that this is based on the contract. Now I'd like to ask two questions. The DOJ answered some questions raised by the Bills Committee last time, and you have quoted case law from the UK, New Zealand, and Singapore. Reading those cases, especially the two from the UK, you can see that as long as the contracting parties do not expressly identify third parties who are to be excluded, and as long as the third party can prove that the contract will have an effect on his rights and obligations, then the court would allow that third party to require the contracting parties to discharge the clauses, meaning the effect of the contract. According to such case law, now I don't know about the experience of implementation overseas, but would it transpire that after implementing the bill, if in contracts there is a long table showing that everybody in this table will not be the subject of the creation of any rights or obligations by the contracting parties. Do you have that kind of experience? This is really a question, you know, I don't know about this. I have read the case law, and I would say if I am a lawyer and if my client wishes to exclude all possible third parties and their rights so as to avoid future trouble, will that phenomenon come to pass? If this phenomenon does appear, then what this bill aims to achieve as a policy objective would be very much dampened. And if that happens, now again, I don't know about overseas experience, would it be like what Mr. or Professor Mason said, that we need another occasion or forum where consumer protection laws would balance against this? In other words, I'd like to know whether there have been such precedents so that we are psychologically prepared as lawmakers. This is the first question. Secondly, I noted that Mr. Peter Wong, the Deputy Solicitor General, said that there would be half a year's time. Now, I did not exactly know how that came about, because the bill does not provide for any delay in commencement or grace period or transitional period. You mentioned half a year. So is that the administration's view, that even if the bill is supported and passed, the implementation date will be set half a year after the enactment? Is that right? Those two questions, please. Mr. Wong. Chairman, with regard to the commencement of the ordinance, will rely on clauses 1 and 2 of the bill, and that is after the bill is supported, the ordinance will come into operation on a date to be appointed by the Secretary for Justice by notice published in the Gazette. As we said in the last meeting, we would like to give half a year for everybody, including the sectors and industries, to get prepared, including formulating a contract template, etc., and also for the administration to do publicity so the public know their rights and how they will be protected. As for the experience of implementation, let us look at UK as an example. In terms of implementation, it did happen in the UK that some standard clauses would exclude certain contracts from protecting third parties' rights. But then it also happened that there was an express provision that the rights would be conferred to certain parties and not others. So that could be realized by the writing of the contract itself. But let us come back to the basic issue as pictured by Mr. Alan Leong. And that is the spirit of the bill is really to better give play to the wishes of the contracting parties, and that is that the third party can enforce their rights through the court or by contract. At the moment, this is not possible, except in exceptional circumstances. So this is a major reform to open up that possibility and so that the wishes of the contracting parties can be better discharged. Can I have a short follow-up, please? First of all, that half year, how will that be formulated? Why not 5 months or 7 months instead of 6 months? Is it that you have considered people who are going to be affected? Say, for example, they might want to examine existing contracts and that the DOJ is of the view that those people think half a year is enough and that they will not need more time. Secondly, now I of course know that the spirit is about spirit of the contract. In other words, you always want to act according to the contract. But I have this question. A and B enter into a contract, and it's quite clear that that contract aims to create a right for C. Say, for example, I can give you this example. Together with Dennis Kwok, I enter into a contract, and I say that the chairman will be able to benefit from some transaction between myself and Dennis Kwok, and I say that if I sell Mr. Dennis Kwok a car, the chairman will be able to have that car 3 years down the road. This is expressly written into the contract, but I also put in another clause. When I enter into a contract with Mr. Dennis Kwok, I put down a clause to say that Mr. Kenneth Leung in no circumstances can enforce that contract. According to overseas case law and in jurisdictions where such policies have been implemented, will that be allowed? In other words, I go back on my words. In the same contract, I create a right for a third party in the contract, but in the same contract, I also write in a clause disallowing the third party to enforce it. Will the court enforce such clauses? I'd just like to seek some understanding into this. Mr. Wong, I'm aware that in para 4.36 of the LLC report, this has been discussed, well, in general. In Clause 4.1 of the bill, there are two possibilities pictured, A and B. A, that the contract expressly provides that the third party may do so, and that is to enforce a term in the court, and B, the term purports to confer such a benefit on the third party. So there is the intention, but then maybe the third party cannot enforce it in the court. If that happens, then 4.3 will kick in. Under 4.1a, the LLC's analysis is that if there is an express provision that the third party can enforce a term in the court, then logically it is not very possible that the court will come to a conclusion that there can be another clause negating the enforceability. Rather, as Mr. Leong was saying, if there is no express provision, then we'll have to make a judgment as to whether that is the wish of the contracting parties. Under 4.1b, that the term purports to confer the benefit. If that's the case, we have to combine that with 4.3, and that is unless the two contracting parties state clearly that there is not that intention, or else the court would defer that the third party's right should be enforceable through the court. I hope I have answered the question by Mr. Leong. As to the second question about the basis for allowing a period of 6 months. Last time we said that our initial thinking is that at least there should be 6 months. On the one hand, we understand the needs of the industries, and in fact in 4.190 of the report, it says that there should be some reasonable period because the bill would have some wide implications for all contracting parties, and so there should be enough time to raise the public's awareness and also for the industries to get prepared. Our judgment is 6 months. But as I said last time, if at this public hearing, if there are other views saying that people need a longer period, we can certainly consider it. Chairman, last follow-up, please. Yes. I'd like to thank Mr. Peter Wong for his replies. So in simple terms, after the bill is implemented, we need to accumulate some case law before things will really become clear. But we are not a pioneer. There have been people who have implemented this for over a decade before us. We are a follower in this. Is it possible that in this legislative process we seek more understanding into the case law in other places, so that we can deal with those in our statute, so the law becomes more perfect? Can the DOJ give us a hand in this aspect? Can you show us the case law that has been accumulated in other common law jurisdictions where similar provisions have been implemented? I understand you have given us a paper today, but I believe that it is an exhaustive list. I believe that paper covers all the case law available. Mr. Peter Wong, can you give us a hand by collecting such case law so that as lawmakers we are more reassured, so that we know we have done everything possible without omitting anything that can actually be done? Mr. Wong. Well, I can answer Mr. Leong this way. In fact, we also think that we should take reference from the experience of implementation overseas. Our bill is actually quite similar to the UK Act, and I can give you an example. In the book contract, starting from page 683, there is a long discussion, and in fact there has been a collection of case law to introduce the actual implementation. Such reference material will be easily available to the legal sector. As for publicity, we hope we can make easy the very complicated provisions, so we can strike a balance between the collection of a lot of case law, because that would be resource intensive, and on the other hand we can rely on such reference books like the Law on Contract. I think that is a very authoritative book with a lot of case law in it.
In our paper submitted to the Bills Council, we have listed several important cases. So the affected parties may have to refer to the past cases. And actually the case law is evolving. and some deputations have already expressed that there are new cases relating to the arbitration clauses, and they said that our amendment is appropriate in the light of these cases. I've read through the book you mentioned, but the question is that the DOJ has experts dealing with this bill. Perhaps I would just narrow down the scope of assistance that I want. Say, if in other jurisdictions there are cases under the common law where rulings have been made, and through statutes rulings of the courts can be dealt with under statutes. So this is the area which I need DOJ's assistance on. Of course, I myself can do research. But since the DOJ has been studying the bill for so long, if you can provide certain assistance in that regard, then that would help in the legislative process. And there may be certain cases in common law jurisdictions, and in which the judge said that the issues can be dealt with statutes, then that can also be done in Hong Kong, and that would be good. Well, do the rulings of these cases help in your drafting of this bill? Will certain clarifications be made because of this? Now, if the bill can be made clearer because of that, then that would avoid uncertainties. Would you be doing some exercise to look at rulings of important cases to see how they impact on your drafting of the bill? Now, if you are going to do that, and if you found after that exercise that that would not have an impact on the drafting of the bill, then we can be more reassured. Now, if you haven't done that exercise, can you do that? You should have time, Mr. Wang. Thank you. I appreciate Mr. Leung's views. For our bill this time, and actually has certainly reflected the rulings of certain cases. For example, in Clause 4.1, we mentioned that it would include a term that excludes or limits liability that has already taken into account rulings of certain cases. In fact, in some overseas jurisdictions, that term or that phrase is not mentioned at all. Now, another example is on Clause 11 on double liability. The LRC suggested that there should not be double liability, but in the UK Act, such a clause is absent. But we think that double liability clause should be included as opposed to the UK Act. So I wanted to say that the bill tries to incorporate rulings from past cases. Of course, as there are more cases, the case law may evolve, and we will try to continue to improve on the law as time goes by. But I think we've done what you suggested already. I have a question. For Section 4.1a and B, the two limbs, the contract expressly provides that the 30 may do so, or the term purports to confer the benefit. I would like to look at the distinction between the two. In my past experience, there is an exclusion clause in a contract. I have this question. If there is an express clause in the contract, to give the third party an enforcement right. But then in the boilerplate of the clause towards the end, the two contracting parties exclude the application of this bill. Then the court's interpretation will usually be giving the third party the enforcement right. That's my interpretation of the of things. Second, if the contract mentions only that the third party has a benefit, i.e. 41B, and then at the boilerplate, there is this clause to exclude the third party's right, and the court's interpretation usually is to respect the contracting party's wishes, and that is to exclude the third party's enforcement right. Is that a correct interpretation? Mr. Wong? Yes. In paragraph 4.36 of the IRC report. Now for 41A, the contract expressly provides that the third party has an enforcement right through the court. So the likely conclusion is that the bill will not be excluded. But as what the chairman said, if it is only conferring a benefit instead of a right on the third party to enforce its rights, then the court may not give the third party's rights to enforce. So I agree with your interpretation. So the 7 deputations have spoken. Members, do you have any views or comments? Yes? Thank you. Mr. Chairman, I have 2 brief points to share with everyone. First, members talked about consumer contracts. There are 2 issues here. We are talking about third parties today. If a consumer signs an agreement to benefit a third party, then that is covered under the bill. But then, if you are talking about a consumer signing a contract with somebody doing purchases, and members asked about stepping up publicity about consumer rights and so on, I believe that there should be publicity. And Mr. Leung suggested that we can take reference from case laws. Perhaps we can share cases and say if a consumer buys something for his or her mom or dad, and that would be covered by the bill. We talked also about Clause 13 about the exclusive jurisdiction clause. Mr. Peter Wong, you said that Clause 4.4, Clause 4.4 is related. I think 4.4 is too broad. Is it possible to subject this clause to reasonable tests, and that may not be similar to the exemption of ordinance clauses ordinance? If the contracting parties confer the right confer on the third parties the rights to enforce, but then stringent additional conditions are included, then that's not good enough for the third party. So would you consider that subjecting to Clause 4.4 to a reasonable test? So if there are any conditions to be attached, the conditions have to be reasonable. So that's what I would propose. Mr. Wong, response? First, about publicity and promotion. As I said, we would try to come up with effective promotion strategies. Earlier on, we enacted another piece of legislation which is difficult to comprehend, and we worked together with the Hong Kong U to do some website publicity so that the public can understand that piece of legislation. We would also consider, again, how to enhance our publicity. You also mentioned about clause 4.4. This is a major principle. Would that be a reasonable test? The crux is that whether the right of the third party is subject to any additional conditions. I think that would be up to the court to decide. Now, Professor Yang mentioned whether there should be a touch of reasonableness. And we didn't, on this regard, we didn't follow the UK Act Clause 7.2 on the exclusion clause. We want to maintain the clause on the third party's rights. So in terms of consumer protection, as opposed to Clause 7.2 of the UK Act, that can certainly reflect our concerns. And for Clause 4.4, I think it's really up to the court to interpret and make a decision. I think it's important that that is clearly stipulated in the signing of the contract. I would like to clarify. I understand all you said. I know that we didn't follow the UK Act in the exemption clause 7.2. So that's why, that's exactly why I propose that, because we didn't follow the UK Act. And in clause 4.4, because it's such a broad clause, would you consider adding in a reasonable test? It's precisely because we didn't follow the clause 7.2 of the UK Act, because all kinds of conditions may be imposed. I appreciate Ms. Yap's concern. But I would like to point out that the contract is to realize the intentions of the contracting parties. If they would like to impose additional conditions, we could not rule out that intention through the clause. Let me cite an example. Say if the two contracting parties confer the right of the third party to use a certain road, and the additional condition is that the third party must maintain the condition of that road, then if the third party doesn't do that, then his right is taken away. Now, if we have to add in a reasonable test, then that will only complicate things. Now, the two contracting parties can't hold third party liable for not maintaining the road, because that is not the intention of the bill. So I think that's so much for the public hearing. If you have not handed in a written submission and if we want to do that, we welcome that. Please do so as soon as possible. If you have new views to make, please also write that down in your written submission. Thank you very much. Thank you.
因為其實有啲嘢可能俾佢哋答返消化。各位同事，咁
members, The meeting will last till 10:30. After having heard the deputations' views, you still have time to express your views on the policies.
We have started clause by clause last time, and we are at clause 4. But if you still have policy questions or questions on the direction of the bill, I think we can still have time to speak on that. Well, Mr. Wong, I have no intention. Please allow me to state at the outset, I have no intention to continue with clause-by-clause examination today because I like to await your written response. Members, any other views on the policy or direction of the bill? Would you like to say anything now? Please raise your hands. We are not going into clause-by-clause again. Any more policy questions? Ms. Sit Ho is here, and I'd like to ask a question on her behalf. She was here. Mr. Wong. That has to do with the exclusion clause, and that should be clause 3. Application. Bracket 4. This ordinance does not
a third party to enforce a term of a contract of employment against an employee. 咁呢個好清楚啦，就
This is very clear.
third party 呢係
In other words, the third party will have a right to enforce the contractual rights against the employer. Does that remain? Yes. Affirmative, Chairman. This excludes employees because we have done so from the angle of employee protection under an employment contract. If the employee is a third party, it can still take out litigation. But of course, if it is a party to the contract, it would not happen this way. But under 4.177 of the LLC report, a possibility is pictured, and that is if the employee is appointed to work for a third party, whether the third party can invoke the contract to apply certain sections or terms against the employee. So this is really to protect the employees. In other words, very often there may be secondment arrangement for employees. The employer may direct an employee to work for his client for 2 months. Under this bill, the two contracting parties, if they want to enforce a term against the employee, only the original employer can do it. Even if there is a secondment arrangement, the third party cannot do it. But very often, the secondment agreement may be a tripartite agreement. I can give you this example. Employer A appoints employee B to work for C at C's place. To express this relationship clearly, it is stated that in the secondment period of 2 months, C can require B to do certain things. So there is a tripartite agreement. Is that separate from the employment contract? How do you view this? Is it that the tripartite agreement is separate from the employment contract as such? If indeed there is such a tripartite secondment arrangement. Thank you, Chairman. In that circumstance, my understanding is that all 3 parties are contracting parties. So in that circumstance, we will not have to invoke this clause about third-party rights. You will just look at the contract and for the duties and obligations of the 3 parties. Members, Mr. Dennis Kwok, I understand that the department is going to write us some written responses. If that's the case, I don't think we should go into clause by clause. Well, I did not have that intention. You didn't listen. Okay. If members have no other questions, I'll adjourn the meeting here. The next meeting can be held at a few different slots. The 20th of May, about 2 weeks later, at 8:30 in the morning. I'll see whether members of the Bills Committee can make it, and then we'll issue the notice. That is the earliest, the 20th of May. Please give us the written response you have promised us so that we can have all the papers ready for the next meeting. And we will continue with clause-by-clause examination next time. Thank you very much. Thank you, administration and members. Sorry, Chairman, if I may. I think deputations have put forward quite voluminous views. I will discuss with the clerk when the written response will be required. If the 20th of May is too early for you, then the next slot will be the 26th of May, a Monday. So we give you another week more. All right? We will tally the time with you again so the administration and members can find a time agreeable to both. And hopefully we can have a few days to read your response. And then at the next meeting, we can have another discussion on policies, and then we'll continue with clause-by-clause examination of the bill. All right? Okay, thank you. Thank you very much. Thank you to all.